effective mechanism. So this is a very forensic commercial topic. So for that, we have with us an esteemed speaker, a distinguished advocate with us, Mr. Prashant Tripathi, sir, who is the founder of PMRT Legal. He's based out of Delhi. His firm is also in Delhi. He mostly practices in the Honorable Supreme Court of India, in the Delhi High Court, NCLT and NCLAT. Also, he practices also in the debt recovery tribunals. He is currently associated with the Supreme Court Legal Services Committee as a counsel. He's a trained mediator also, and his expertise lies in forensic commercial subjects, including ADR, SAFAC, company law, IBC, that is Insolvency and Bankruptcy Code. Sir has also represented clients like NBFCs, HFCs, and the dedicated Freight Corporation Corridor of India. So it's an honor to have you here, sir. The floor is yours.
Thank you, Soumya. Thank you for such a nice introduction. I hope I am audible and visible to all of you.
Sir, you are not audible.
Can you hear me now?
Yes, sir. You are audible.
Yes, yes.
Thank you. Thank you, Soumya, for such a nice introduction. In fact, the topic that we have decided for the discussion is also, see, there can be no fixed conclusion to the topic, but it is open to discussion beyond all limits. We all have our views. We can discuss those views. One may favor arbitration, the other may favor mediation. But my view simply is that both have their different application, both applies to different fields, and both applies to different situations. We cannot firmly say that for all nature of disputes, you need to opt arbitration or mediation. So let's start with this. So we all know that every dispute that we have present two choices. One is to fight until the end, and the other is to resolve it in the most effective manner. As lawyers, our job is not merely winning cases. It is choosing the right mechanism to resolve disputes. With this perspective in mind, I think we have decided to discuss on arbitration or mediation. We all know that for decades, in fact, even today, litigation has been regarded as the natural course wherever a dispute arises. Whether the disagreement involves commercial contracts, construction contracts, or any other nature of disputes, the usual recourse has always been to approach traditional courts. However, in recent times, I would say, let's say for 10 years or more, for last 10 years or more, there's a change in the perspective. There is a change in the perspective of the clients as well as the lawyers. Courts have also emphasized on promoting alternate dispute resolution. The primary reason is the time that is being consumed in deciding a case by a traditional court. So time is lost, money is lost, efforts is lost. Many times the purpose and the relief that are being claimed by the litigants also becomes infructuous because of the time that is being taken by traditional courts. So now, because of these flaws, the trend has changed and is still changing. The shift is what is quickest, most commercially sensible, and cost-effective way to resolve a dispute. We all know how our courts are functioning. There is a huge pendency of cases to be decided. And in fact, if the recent survey is believed, it has been stated in the said survey that assuming that no fresh cases are filed from today onwards, it will still take more than almost, I think, 300 years to decide the pendency of the cases that we have. So better to not opt courts, or we let's say let's decide to prefer ADR. But why ADR? Suppose let's discuss an example. Let's take imagine a situation where a contractor raises a claim of 100 crore against an employer under an infrastructure contract. Now, if the dispute remains pending before the court for suppose 10 years, 5 to 6 years to 10 years has become a common for now courts to decide. So suppose the dispute remains pending for 10 years, several things may happen. The project may become commercially irrelevant. The courts may escalate, the cost may escalate. Uh, Many personals or the workers who are working in the project may leave. Documentary evidence may become difficult to establish. And most importantly, the commercial relationship between the parties may completely collapse. So even if the successful party ultimately obtains a favorable judgment, suppose 10 years later, the commercial value of that victory may, or less, I think it will significantly diminish. So just to avoid all these things, the ADR has evolved. I would say it is not a new concept. Our society has recognized ADR since ages. Indian society, we had panchayats, village panchayats, where a few especially 4 to 5 people, or the elder respectable person of the society, used to resolve disputes. And they were quite efficient and quick disposal of those disputes. But with time, we moved to traditional litigation, the coded statutes we got courts, and with the pendency of cases, now again we are going back to ADR that was prevailing earlier with us. Now, mediation has been recently introduced formally in our country with the Mediation Act 2023. Before that, we had Arbitration and Conciliation Act. Earlier, it was Arbitration and Conciliation Act 1940. Then we had, pursuant to ancestral model law, Arbitration and Conciliation Act 1996. This, in fact, became a watershed moment by aligning Indian arbitration law with the internationally accepted principles that were embodied in the ancestral model law. Subsequent legislative amendments in the Arbitration and Conciliation Act in 2015, 2019, and 2021 sought to make India a more arbitration-friendly jurisdiction by reducing judicial intervention, introducing timelines, strengthening arbitrator independence, and promoting institutional arbitration. Our courts have also acted very promptly to safeguard the sanctity of arbitration. They have passed numerous judgments. One of the few that I would name would be Perkins, where the courts have now completely barred unilateral appointments of arbitrator. Though the pros and cons of every judgment, every statutes are there, but primarily the honorable courts have emphasized that it should be a transparent and unbiased process. Significantly, we turn to Mediation Act 2023. It is now a coded legislation that we have. It is for the first time that we provided a comprehensive statutory framework governing mediation in India. We'll discuss all these concepts, arbitration and mediation, in a while. So there are various factors that needs to be considered while deciding which mode to opt. We'll discuss all this. But before deciding which to opt, whether arbitration or mediation, we'll first discuss and understand what arbitration is and what mediation is, and then we'll decide that discuss the differences between arbitration and mediation, and ultimately we'll discuss what are certain factors based on which we may take a call whether to opt for arbitration or mediation. So the first question that is before us is what is arbitration? So at its core, arbitration is a consensual adjudicatory process. Instead of approaching a court, we have received a question from one Mr. Piyush. What is the role of ADR lawyers in ADR? We'll address this question definitely at the end of our discussion. Please remind me to discuss this question. So at its core, arbitration is a consensual adjudicatory process. Instead of approaching a court, parties agree that any dispute arising between them shall be decided by an independent and impartial arbitrator. So an arbitrator adjudicates the dispute. The tribunal hears evidences, interprets the contract, applies the applicable law, and finally renders an arbitral award, which is binding upon the parties and enforceable in the same manner as a decree of a civil court under Section 36. So an arbitral award has been given by deeming fiction a decree of civil court under Section 36. Obviously, a person who is aggrieved by that award can challenge it under Section 34, and a further appeal is under Section 37. Though grounds for challenging an arbitration is extremely limited as provided under Section 34, subsection 2 of the Arbitration and Conciliation Act, but that's not the part that we will discuss today. So a basic few features of arbitration is party autonomy. The most important feature is party autonomy. And now what is party autonomy? Party autonomy in simplest term is that the parties have right to choose their forum, to choose the arbitrator to decide who will decide their dispute. Section 11 subsection 2 expressly recognizes this concept of party autonomy. It confers upon the parties to decide the mode of resolution of their dispute. And only in those cases where the agreed mode is not resorted to or could not be resorted to by the absence of consent of one of the parties, then further subsections of Section 11 provides recourse to the respective courts. So, unlike litigation where the law determines the forum, procedure, and presiding judge, arbitration allows parties to tailor the dispute resolution process according to their commercial need. What they want, they will have to decide. So parties may decide as part of this dispute, basically the process, parties may decide whether dispute shall be arbitrated, whether there will be one arbitrator or a tribunal of 3 arbitrators. There cannot be 2 arbitrators. That is expressly barred under the provisions of Arbitration and Conciliation Act. And what would be the qualification and expertise of an arbitrator? Suppose the subject matter of dispute involves some complicated questions of law, or it involves a field where expertise of certain individual is required. So parties will have the choice to choose a person of that particular expertise. What will be the governing law? Whether the law of India will apply or whether law of any other country will apply. What will be the language of the proceedings? What will be the seat and venue of the proceedings? Which whether they want to resort to any arbitral institution. There are a number of arbitral institutions. We have DIAC, Delhi International Arbitration Center. We have SIAC. There are a number now. IIC also there. So what is the legal framework that governs the arbitration? So I already mentioned that is expressly governed by the Arbitration and Conciliation Act 1996. Various attempts through amendments have been made to reduce unnecessary judicial intervention, to promote institutional arbitration, to ensure independence and impartiality of arbitrators. I already mentioned the judgment of Perkins, and the recent judgment is Encore 2. We call it Encore 2, wherein it has been authoritatively held by a constitution bench that there cannot be a unilateral appointment of an arbitrator. That is expressly barred under Schedule 7 of the Arbitration and Conciliation Act, read with Section 12, subsection 5. These amendments have also sought to introduce statutory timelines like Section 23, subsection 4 and 3 and 4 provides for 6 months for completion of pleadings, and then We have also timeline provided under section 29A, where 1 year has been given for disposal of arbitration cases, and in case that is not possible, then with the consent of parties, 6 months further extension can be given, and further extension can be given with the permission of the court. So statutory timelines have been provided to ensure that arbitration proceedings are completed in a speedy and timely manner. Then we are also working to promote India as an international arbitration hub. Various efforts are being made in that direction, and we are hopeful that we'll be able to achieve that very soon. So how does arbitration comes into picture? So the first step obviously is the dispute. Suppose a dispute has arisen between parties. Now, what happens once a dispute has arisen between the parties? The parties, in compliance with their agreement, whatever they have agreed. So the agreement usually contains an arbitration clause, which states that any dispute that may arise between the parties in relation to this agreement shall be referred to an arbitrator, and then parties may decide whether they will choose the arbitrator or they will approach the courts for appointment of arbitrator, or they will approach any arbitral institution for appointment. Then they also decide where will be the seat, where will be the venue, and then the clause also states that the award passed by the arbitrator shall be binding upon the parties. By stating that the award shall be binding upon the parties, it doesn't mean that the parties will not have a right to challenge. Obviously, right to challenge has been given under section 34 and further challenge under the 37 section. So these are there, but the award will be binding on the parties. They cannot say that, oh, now the arbitrator has passed the award, it is just not, I'll not comply with the award. Unless they challenge it, they are bound to follow it. And unless there is a stay by a superior court, they are bound to comply with the directions or the arbitral award that has been passed in favor or against them. So the first step is invocation notice. Section 21 states that the arbitral process shall be deemed to have commenced on the date when the notice invoking arbitration has been received on the other party. So the first step is you issue a notice under section 21, whereby you invoke the arbitration clause. You state that so and so dispute has arisen between you and the other party, and that now you want to proceed for arbitration. The mechanism that has been provided in the respective arbitration clause will have to be followed. Then the second step is, once you have issued the notice invoking arbitration, the second step is the constitutional of the arbitral tribunal. Whether there is a single arbitrator or a bench of 3 arbitrators, whatever is mentioned in the arbitration clause will have to be constituted accordingly. Then once the arbitration tribunal has been constituted, the claimant will have to file its claim. The respondent will have to file a statement of defense. It can also file a counter claim. Whatever the situation is, parties have to act accordingly. This part has to be completed within 6 months as per section 23. Now, once the pleadings are complete, the arbitrators usually, if required, frame issues, decide the burden on which party will be there to prove which issues. Then evidences are led by the respective parties in support of their claim. Then hearing takes place. Both parties advance their oral arguments, refer to their pleadings, and then they file their written arguments subject to the permission by the arbitral tribunal or whatever the mechanism they have agreed. Then based on the evidences, based on the pleadings, written submissions, an award is passed. And if the award is not complied with by the party who has lost the case, or in whose favor, against whom the award has been made, if that party fails to comply with that award, the party who has won that arbitral award, or in whose favor the arbitral award has been passed, has the right to proceed for enforcement under section 36 of the Arbitration and Conciliation Act. So these are 6 to 7 steps. I'll just repeat it. The arising of disputes, invocation of arbitration clause by issuing notice under section 21, constitution of arbitral tribunal, then pleadings, whereby you file claim, statement of defense is filed by the other party may also file counterclaim, the response to counterclaim has to be filed then by the claimant, then evidences, then hearings, award is passed, and the final stage is the enforcement. Enforcement has to be as per the provisions prescribed under Order 21 of the CPC, just like a decree of civil court. Now, we have primarily two types of arbitration. One is the institutional arbitration, the other is the ad hoc arbitration. In simple terms, institutional arbitration is by certain designated institution. Suppose Delhi International Arbitration Center. Ad hoc arbitration, on the contrary, is basically it is a informal way of conducting or resolving disputes by the agreements of parties, whereby they choose an individual to decide their dispute. Contrast to institutional arbitration, where the institution chooses the arbitrator. Okay, so there are other institutions that I mentioned. MCIA is there, SIAC is there, ICC is there, International Commercial. Then what does an institutional arbitration offers? It offers you an administrative support. Then it also, suppose just take an example, or I'll just let you know. The DIAC has its own rules. It prescribes rules as to how the arbitration under its aegis will be conducted, what will be the fees, what will be the administrative support that they will provide, how the proceedings will run from first stage till last stage. So that's how an institutional arbitration goes. The institution provides you all sort of these supports. Then when it comes to ad hoc arbitration, the parties themselves manage the proceedings. There is no external support by any institution. This approach provides greater flexibility, but at the same time, it may also lead to disagreements regarding procedural timelines, fees, appointment of arbitration, conduct of hearing, etc. That is not there in the institutional arbitration because there is a structured mechanism provided under their respective rules, and the parties have to follow that. Whereas in ad hoc, since the parties themselves have to agree, there may be lapses and disagreements on various issues. In fact, many delays commonly associated with arbitration arise not because of the statute, but because of the poorly managed ad hoc proceedings. So that precisely because of these reasons, there has been a shift towards institutional arbitration in India now. Courts are promoting, lawyers are promoting, and parties themselves want institutional arbitration over ad hoc arbitration. Then one of the benefits of arbitration is the right that has been given to the parties, both. It may be claimant, it may be the opposite parties. Both have been given a right to seek interim protection. In fact, there is a judgment of the Honorable Supreme Court also that has categorically dealt with the issue that whether a party who has lost the case or against whom the arbitration award has been passed, can that party seek interim protection under Section 9? And the Honorable Supreme Court has categorically held in favor of that issue. So interim protection is one of the crucial distinguishing factor that promotes arbitration. Parties have a right to approach respective court and seek certain interim measures. Suppose a borrower attempts to dispose of secured assets. Suppose there's a case of bank where a loan has been granted and a property has been mortgaged. Section 9 may come into picture for seeking certain interim protection against the property that is intended or apprehended to be disposed of or alienated or in any manner dealt with to the prejudice of the lender. So in that case, a lender may approach Section 9 of Arbitration and Conciliation Act. There may also be a case where a contractor may seek to invoke bank guarantee. In that case also, interim protection can be availed of. There can be other situations. There basically A to E, 5 clauses, 5 situations have been provided under Section 9 where if your case is falling under any of those situations, you may approach the respective court for obtaining interim protection. In fact, The best part is Section 9 enables the parties to approach the court for obtaining interim relief even before the constitution of arbitral tribunal. Even after the passing of award, that protection is available. Earlier, Section 17, which enables parties to approach the arbitrator and seek interim relief, also provided that after passing of the award, arbitral tribunal also had that power. Now that doesn't exist anymore. It is only the Section 9 that allows, even after arbitral award has been passed, Section 9 can be taken recourse to and interim relief can be obtained. So these powers ensure that the arbitral process remains effective and the final award does not become merely academic. Then another distinguishing factor is the finality and limited judicial review. I already mentioned that that against an arbitral award, there is a challenge available, mechanism to challenge the award has been provided, but the grounds on which the award can be challenged are extremely limited. So a common misconception among litigants is that arbitration merely adds another stage before approaching the court. That is incorrect. One of the arbitration's greater strength is the limited scope of judicial interference. Unfortunately, as of now, the courts have been excessively interfering with the arbitral awards, but at the same time, some courts are uh, making observations, taking a stand that there needs to be limited judicial interference against an arbitral award. In fact, though Section 34 in general parlance is understood as an appellate mechanism, but actually courts, while exercising their powers under Section 34, do not function as an appellate authorities. Public policy ground, there may be a situation where the party was not provided adequate opportunity, there has been a violation of natural justice, or the award itself contravenes any of the substantive law, then these are limited grounds where challenge can be permitted. Just because a different view is permissible based on the evidence, that is not a ground to challenge an arbitral award. There can be 2-3 ways or views of different persons. But if a view that has been taken in arbitral award that is tenable, the courts will not interfere with it. Now, having understood the arbitration process, we will just highlight the advantages of arbitration. So, from a commercial perspective, arbitration offers several distinct advantages. First is it is binding and has an enforceable outcome. It promotes party autonomy. It promotes confidentiality between the parties, and in fact, it ensures confidentiality of the proceedings that have taken place. Then it also allows you to choose technical or subject matter experts as an arbitrator. Then there is a procedural flexibility, though not to the extent the flexibility a mediation provides. Limited jurisdiction, I already mentioned. Then greater commercial certainty is also there. For high value contractual disputes, these attributes frequently make arbitration preferable to conventional litigation. So, in fact, we are seeing as a practical lawyers, we have been regularly seeing that in high value contractual disputes, the most resorted to mechanism is arbitration. Parties are not willing to go and opt the traditional courts. They prefer commercial arbitration and they get their disputes resolved. At the same time, there are certain limitations to arbitration also. We have seen the advantages. Now let's focus or discuss the limitation of the arbitration. It is, as I said in the beginning, arbitration is not a universal solution. Parties should also recognize its practical limitations. In fact, day in and day out, we have been observing, noticing certain limitations, certain shortcomings of arbitration also. So, suppose complex arbitrations involving multiple arbitrators, senior counsel, technical experts, and extensive evidence may become expensive. In fact, uh, I think in the month of May or June, The Honorable Rajasthan High Court has pointed out a case which has been an arbitration case which has been pending for for last 7 years, and the parties have already paid more than, I think, 25 crores or some. I may be wrong, but it was in huge. A huge amount was paid only as an arbitrator fees. So this is one of the limitations where parties have incurred fortune. They have, the arbitration fees have costed them fortune, but still they are waiting for resolution of their disputes. Another limitation that can be is poor case management. It may also result in delay. As I mentioned, section 34 only provides limited grounds. So limited grounds of challenge may also prevent correction of factual errors, though section 33 has been provided under Arbitration and Conciliation Act, but the limited scope that is available under section 33 is correction of arithmetical errors. Then arbitration may be suitable only for dispute capable of private adjudication and generally requires a valid arbitration agreement. So suppose there is an agreement between the parties, but the arbitration clause contained therein is not valid, or the dispute that has taken place between the parties is not covered by the arbitration clause, then also arbitration cannot be taken there recourse to. Another problem is the poorly drafted arbitration clause. Suppose there is a situation where the clause says, in case the disputes between parties arise, parties may take recourse to arbitration. So the Honorable Supreme Court has interpreted this, a similar clause where the word may was used, and the Honorable Supreme Court has categorically held that this clause was not valid because the intention of the party is not definite. It raises a situation, it raises a possibility that the parties may take recourse to arbitration. That should not be there. The intention should be clear and unequivocal. So these are few limitations of arbitration. Now, having considered and discussed arbitration, its advantages, limitations, we swiftly move to mediation. Now, what is mediation? See, both arbitration and mediation are part of alternate dispute resolution only, but they differ in practical applicability. I explained you what is arbitration. Now let's discuss mediation. So mediation in simple terms is a voluntary, confidential and structured negotiation process in which independent third party, who is called mediator, assists disputes between the parties. It only facilitates, basically it facilitates parties in arriving at a mutually acceptable settlement. Unlike arbitrator, where proceedings take place, parties file their claim, then contesting claim, they file their evidence, hearings takes place, evidences are evaluated, and arbitrator passes a decision. Just like a court, arbitrator passes a decision which we call as an arbitral award. These things don't happen in mediation. So I'll give you a practical picture of how arbitration, how mediation proceeds. Suppose you have filed a case. Suppose the family members have a dispute. Or suppose in matrimonial cases, the husband and wife have filed cases against each other. There may be an employer dispute between employer and employee, or any other kind of dispute, or a commercial dispute, say, where a party is claiming dues from another party. Now, though in commercial matters, the law says, the Commercial Courts Act say that taking recourse to pre-mediation litigation is mandatory under section 12A. I'll explain it later on if we have time. Abhi, for the time being, we are just assuming a situation where two parties have filed cases against each other, or suppose one party has filed a case against the other, and there is a possibility of settlement. In fact, if you see and read section 89 of Civil Procedure, CPC 1908, it casts an obligation upon the courts dealing with the subject matter to evaluate if the dispute between parties can be resolved through ADR mechanism. And if the court finds it that there is a possibility that disputes can be referred to mediation or can be resolved through mediation, it can ask the parties whether they are agreeable to take recourse to arbitration and explore the possibility of settlement. See, mediation cannot be imposed upon any party. Neither parties to mediation can be compelled to settle. The role of mediator is only to facilitate. So how the practical process approach? Here, the example that I gave here, the courts have referred. In the same situation, one of the parties can say that that party is ready to settle the dispute by mediation. And if the other party agrees, both parties can be sent to court annexed mediation. Okay. So when that dispute is referred to court annexed mediation, before referring, parties have to sign a form in this court that they are willing to resolve the dispute through mediation, or at least explore the possibility of settlement through mediation. So both parties are asked to approach the mediator. They are allotted a mediator. All the courts have now with them annexed mediation cells where trained mediators are there. They are subject matter experts. Accordingly, their parties are referred to respective mediators. Mediators introduce themselves. They explain the entire process of mediation. They also explain what are the limitations, what are the role of mediators, and to what extent mediators will play their role. Once they have explained the complete process and the role in which and the manner in which the mediation proceedings will take place, they, subject to the situation and circumstances there, the mediator can hear the parties first jointly. They can ask the claimant to narrate his or her case, and after hearing claimant, they can ask the other party to explain his or her case. Then, after hearing both the parties in joint session, mediators usually take recourse to single session, which we also called as caucus. In single session, parties discuss more openly their situation with the mediator. Mediator's role is only to facilitate. He listens to both the parties, even in single sessions. And if there is, suppose, a situation, or if there is information that the mediator intends to share to the opposite party, he or she will have to first seek consent of the party who has given that information. Without the consent, mediator cannot share that information with the other party. So this is a very crucial factor. It ensures that confidentiality remains intact even when the party has shared the information to the mediator. Just because mediator is presiding the process, he is not automatically authorized to share each and every information. For every information that he or she intends to share with the other parties, consent is required. Then, as I mentioned, mediator does not adjudicate the dispute. Arbitration, may I explain that there are pleadings, and based on those pleadings and evidences, arbitrator adjudicates the dispute. Here, there are no pleadings at all. In fact, nothing gets recorded. Nothing gets recorded. No documents are taken on record. So our mediator only listens to you. And for its own understanding, it may, by pencil or pen on a rough paper, note certain factors so that it can facilitate the process. But there are no records that a mediator makes while listening to both the parties, while facilitating the process. In fact, the mediator does not determine liability. The mediator does not pronounce the judgment. He only facilitates communication, identifies common interest, encourages negotiation, and assists the parties in exploring workable solution. Mediator does not give any solution. He or she only facilitates. The solution is also given by the parties themselves. The role of mediator is just like a prism. or mediator's role is just like a sieve where he clears or determines the conflict that the parties have. Mediator's role shifts and focuses shifts from who is wrong, who is right, to what is the problem. So mediator focuses on the problem that is there between the parties. His attention, his focus is not on which party is right or which party is wrong. So once he has determined the dispute between the parties, he will try to discuss on the possible solution, and the possible solution will also be shared by the parties only. So suppose there is a situation where we have a orange. There is a dispute between two parties. Both parties are claiming oranges. There is one orange and both parties are claiming the same. So mediator's role is to understand the needs of respective party. There may be one of the parties only needs the internal portion of the orange because he's a juice seller, so he wants that internal portion. The other is, suppose, any other person who wants the external cover or the peel of orange. So as a mediator, he will understand the needs of both parties and then propose or understand from the party itself that what if you are given the peel and you are given the internal pulp portion to, will it be okay to you? And both parties will agree. So this is how the mediator resolves a dispute. He does not adjudicate ki aap galat ho ya ye galat hai. So if we analyze both processes, in an arbitration process, arbitrator decides, the mediator only facilitates. The parties themselves resolve the dispute. This is the single distinction that defines the philosophy of mediation. It is the parties who are the judge in their own case. Mediator is only facilitating the resolution of disputes. In fact, a lot of family disputes, long pending family disputes, have been resolved by way of mediation. So, though I've already stated, but I'll again mention a few things. A philosophy of mediation, if we say, so traditional litigation and arbitration primarily focused on rights. Mediation focuses upon the interests of party. So let's consider a dispute concerning delayed payment under a supply agreement. A court or a tribunal will ordinarily ask, was there a breach of contract? Who is liable? What damages are payable? Contrarily to that, a mediator will ask different questions. And what are those questions? Or say the possible questions. The reason, why has the payment stopped? Can payments be restructured? Can future business continue? And is there a solution that is beneficial to both parties? So let's notice the difference. One process, that is arbitration or traditional litigation, they determine legal liability. Mediation, on the other hand, seeks and determines the commercial sustainability. As lawyers, as someone asked, as lawyers, understanding this distinction is essential because clients often require solution, not merely judgments. In fact, when I'll answer that question, the role of lawyers, there is a misconception in the lawyers fraternity that mediator or the Mediation Act is going to adversely impact the lawyer's work. That is not correct. That is in fact a misconception to a larger extent. I'll explain this at the end. So now we have a structured Mediation Act 2023. It also promotes institutional mediation. It encourages pre-litigation settlement. In fact, the proposed amendment to CPC, as of now, we only have pre-litigation mediation in commercial matters. The proposed amendment, if notified to CPC, will in fact add pre-litigation mediation to all sort of disputes covered under CPC. It also reduces judicial backlog, recognizing online mediation. In fact, while I was being given training, uh, I think in 1 week we resolved almost uh, I think 100 or odd matters. So see the disposal rate. Parties go happily outside mediation rooms. They are happy that both have won. Both have got something or the other that they would never have got in traditional courts or arbitration. Then another important fact that Mediation Act recognizes is it provides legal sanctity to mediated settlement agreement. It is not as if the process is informal, so anything can be agreed and then parties may retract. That's not the case. So whenever a mediation dispute is resolved, the terms and conditions that both parties have agreed are reduced in writing by the mediator. Both parties read those terms, and once they have confirmed that yes, these are the terms that were agreed by the parties, mediator signs it, parties signs it, and a copy of that mediated settlement agreement is given to the parties. I've already explained you the process of mediation. If you want, I can repeat it. So dispute arises, parties agree to mediate, a mediator is appointed, usually court annexed mediation is there. So a mediator sits within the precincts of the court in designated rooms. Then there is an opening session. Opening session is where the mediator explains the process of mediation, how the process will run, and what will be the role of parties, how will they explain their case. Then once this process has completed, mediator by in joint session or single session identifies the issues, discusses everything with parties. Then it promotes negotiation, facilitates the process, and once the parties have agreed upon the terms and conditions that for settlement, a mediated settlement agreement is executed and signed by the parties. As I stated in the beginning, there are no pleadings resembling in a civil suit, no cross-examination, no formal evidence, no judgment, nothing. It is only a process that remains guided by dialogues rather than procedural formalities. I also explained you the confidentiality. Even the mediator cannot share the information of one party to the other party without first having obtained the consent of the party. Because see, trust and confidentiality are the cornerstone of mediation. Parties during discussion often enclose their internal commercial strategies, their financial constraints, their settlement expectations, their concerns, their commercial priorities. So many confidential details and informations are shared. So it is a duty of mediator not to share it without the prior permission of the other parties. Then mediation, there is a restriction or there is a limitation of mediation where it can be applied. So in criminal matters it cannot be applied. Now in fact attempts are being made to apply it in petty offenses, but that will still take time. Mediation is also agreed to be made applicable to dispute resolution under insolvency and bankruptcy code. Then IPR disputes. See, banking and financial transaction, if we talk only about the loan recovery process, mediation is already being taken records to by the parties, and a huge number of disputes are being resolved by the parties every now and then. Mediation in a way facilitates, if we talk about the banking process, parties may explore loan structuring, the one-time settlement. They may also explore revised settlement schedule. What is, suppose the already given collateral has suffered some damage or its value has gone down, additional collateral or security can be given. So number of options are available. It can be also applied to shareholder disputes, employer disputes, infrastructure and construction disputes. Now, the role of lawyers in mediation. So now I'll answer that question that was raised. So I already said that there is a misconception that mediation diminishes the role of legal counsel. In fact, the opposite is true. An effective mediation advocate performs a highly strategic role. We have been advocates in number of mediation cases. We have also seen the role of advocates as mediators when we sit as mediators. So the lawyer assists the client in identifying the interest, commercial priorities. Then it also informs the client what are the litigation risk, what are the options or possibilities of settlement, how the rights of those parties will be safeguarded. And it also, in fact, ensures that the mediated settlement agreement that the parties have agreed upon is drafted in an unambiguous manner. So there is no ambiguity in the agreement that has been drafted by the mediator. Another, in fact, if we talk about practical picture, as parties, as councils, as a banking council and as a borrower's council, often what we advise is, suppose you have a client who is adamant on taking recourse only to DRT or any other court. He's ready to put in all efforts that are required because he has taken it on his ego, or he may have been genuinely harassed by the bank or the other party or any other employer, say. In such cases, you try to inform and in fact guide and counsel the client that, see, if you file a case, there is no problem in filing a case. You have that legal right to file it. But now when you have filed a case, the usual time taken by this particular court to adjudicate upon the rights and liabilities of a party and to decide the case is, say, 6 years. Are you going to wait for 6 years for resolution of your dispute? Now, when you will file a case, certain expenses will be incurred by you. You will also have to bear the lawyer's fees. You will also have to travel to attend court many times. You will also have to put in lot of efforts. So a lot of time, efforts, money will be saved. And after 6 or 7 years, if you get your resolution, that is actually not a resolution per se. Now, I'll explain the benefits of mediation to that party. I'll say, suppose you are claiming dues of 1 crore. There might be a case that if you file a case before the court, you may get 1 crore, but you will lose 6 years. You might get certain interest, but that interest after 6 years may not be profitable to you. Contrarily, mediation may give you 90 lakh, but that would be an immediate resolution. You will not be burdened with lawyers' fees, the court's efforts, running here and there for court, attending court matters, etc. So we need to highlight these benefits of mediation to your client. This is the role. In fact, your role as an advocate does not end only to client counseling. You also participate in the mediation process. You guide your client at each and every step of the mediation process. Throughout, your role as an advocate is intrinsic to the resolution of disputes. The better you guide, the better is the resolution of dispute. Whenever your client faces a situation, he or she is in a dilemma in which path to opt, what solution or what option that has been given by the other parties to opt. It is you as an advocate who has to guide that party. You as an advocate have to explain the pros and cons of the possible solution or the option that a party is intending to opt. Then, as I mentioned, you also play a role in vetting the mediated settlement agreement. You will go through that mediation settlement agreement and then highlight if there is any ambiguity, or if the mediated settlement agreement records any terms and conditions that was not agreed by you or the other party, or suppose they have mentioned that terms and conditions, but a perusal of those terms and conditions show that your client is getting prejudiced, then you as an advocate has a role to highlight that and ensure that interest of your client is safeguarded. So role of an advocate throughout mediation process is indispensable. Nobody can say that, oh, Mediation Act has come into picture and now the advocates will have no role. Advocates have an indispensable role, and they need to understand that thing and perform their duties properly, because without advocates consultation and guidance, mediation cannot be. Obviously there may be certain exceptions where parties themselves are in a position to understand pros and cons of everything that they are discussing, but in majority 98% cases it is the advocate who will guide them, who will make them understand of the entire process, of the consequence of their decision, of the consequence of the possible solution. So please understand that advocate's role is vital and is an intrinsic part of the entire mediation process. In fact, once a mediation settlement agreement has been executed, there are grounds that have been provided to challenge. It is the advocate who will guide the client if the mediated settlement agreement can be challenged, or on what ground it can be challenged, what are the possibility of getting the challenge successful. So now, as an advocate, our role is not limited only to appearing and arguing cases and drafting cases before the courts. We in fact have become a negotiator. We also devise strategies. We also try and put in our best efforts to manage risk to our client. We also propose solutions that are commercially viable and fruitful to our client. And obviously, we are solving the problems for our clients. So that has always been there. So these skills increasingly define successful legal practice. Now, what are the benefits of mediation? I'll just quickly take, it is a faster resolution. It cost effective. Court annexed mediation, you don't incur a cost at all, or the cost incurred is, if at all a cost is charged, it is minimal. Confidentiality is there, flexible procedure is there, party controlled outcome is there, commercial relations, family relations are preserved. Then you have that leverage to promote and to explore, and business disruptions are reduced to a larger extent. Now, there, as I mentioned, limitations for arbitration, limitations of mediations are also there. Not every dispute can be resolved through mediation. Mediation may prove ineffective where one party refuses meaningful negotiation. Suppose the other party is coming only as for a formality in the mediation process, and it is not participating, not giving meaningful negotiation, is not agree to give some concession and agree on the proposed solution, then it becomes ineffective. Then matters related to complex fraud or similar criminal allegations, those disputes cannot be settled by way of mediation. Where injunctive relief is essential, that was there in section 9 arbitration, mediation you cannot claim any interim relief. Then there may be other situation where there is a significant imbalance in bargaining process, also prevents at times fair negotiation. So in those situations, arbitration or litigation may be the preferable recourse. Now, the main subject of our topic, mediation versus arbitration. Which one to choose? Now, as I mentioned earlier, both are parts of ADR, both are recognized under Indian law, both seek to avoid the delay of traditional litigation, both are confidential, both are increasingly preferred by commercial entities. Yet, despite these similarities, they are fundamentally different in their philosophy, process, and outcomes. So suppose your client asks, which is better, mediation or arbitration? The answer always has to be simple, and the answer is neither. Neither arbitration is better nor mediation is better over each other. So you cannot say that in all cases arbitration can be done or in all cases mediation can be done. The decision whether arbitration can recourse to arbitration is possible and better or recourse to mediation is permissible depends totally and entirely on the facts and circumstances prevailing in that particular situation. In fact, the better question would be which mechanism best serves the client's interest. Based on your client's interest, you need to decide whether arbitration is required. Suppose an adjudication is required, then obviously the answer has to be arbitration. But suppose the situation is where there is a possibility that negotiation or discussion talks can resolve the dispute, then obviously mediation is there. So if we discuss the differences, if we talk about the nature, arbitration is adjudicatory, mediation is, as I mentioned earlier, it is facilitative. Decision maker in arbitration, it is the arbitrator who decides the dispute. In mediation, it is the parties themselves who decide the dispute. Result is, in arbitration, an arbitral award is passed. In mediation, settlement agreements are executed. In arbitration, one party usually loses, the other party wins. In mediation, that's not the case. In mediation, both parties usually win. So it is a win-win situation for both parties in mediation. Procedure under arbitration is structured, whereas in mediation, it is a flexible process. No evidence as such is required in mediation that is required under arbitration. Duration for mediation, it is 90 days. For arbitration, it has to be 6 months for pleading, then 1 month for resolution, basically for passing of award. And in cases where this award is not passed within a year, further extension of 6 months and further extension are possible. Cost, arbitration as compared to mediation, cost is higher. Mediation, there is almost negligible cost. Then confidentiality in arbitration, there is confidentiality, but if you compare the confidentiality with mediation, in mediation it is very high. So arbitration in certain cases may preserve the relationship, but mediation in most cases, it will preserve the relationship between the parties. And arbitration is suitable for right-based dispute. Mediation, on the other hand, is suitable and in fact best suited for interest-based disputes. Now, having discussed all these things, so I've already chalked out the factors that are there for deciding whether to take recourse to arbitration or mediation. I've already highlighted all these things. In fact, there is one more factor that may be taken into consideration while taking this decision of arbitration or mediation is the expertise. Suppose the expertise of a person is required. The subject matter is such where the expertise is required, then you may take recourse to arbitration. That may not be possible in mediation. Then there may be obviously disputes, nature of dispute that needs to be taken into consideration while deciding this thing. Now, having discussed all these things, it is always advisable to explore mediation before commencing adjudication. In fact, if you will see contracts nowadays being drafted, they always prefer resolution of disputes by way of negotiation or mediation before taking recourse to arbitration or traditional litigation. So that shift is actually worth appreciating. We need to put in efforts to promote resolution of disputes by way of mutual discussion, mutual talks. In fact, the future of dispute resolution is not arbitration versus mediation. The future lies in choosing the right mechanism at the right time for the right dispute. That is the hallmark of our legal profession now. Now, with this, I'll end my session. Now it is up to you to raise questions if there are any. Usually, I think I answered your question. What is the role of lawyers? If there is any further question, or if anyone else has any other question, please feel free to ask.
Yes, sir. Good evening, sir.
Please.
Yes, yes. It's a very fruitful session, and you answered my question. So there is one more doubt. If there is any misconducting in agreement from the starting, or both parties signed on the agreement, is it valid, or
No,
can?
see, once the parties have signed the agreement, it is valid. But at the same time, the provisions of Mediation Act permits you. Suppose you were induced or you were misguided and influenced to sign the agreement. While signing the agreement, you did not had the proper understanding of those clauses, or if the other parties has influenced you, or say the mediator has influenced you, then in limited circumstances a remedy is provided under Mediation Act 2023 to raise a dispute and challenge the award, rather the mediated settlement agreement itself. So a remedy is provided in the act itself.
Sir, if one party is already mentioned in the agreement that the arbitrator is like defined only by the one party, and uh, the seat will be decided by the one party, is second party can challenge the agreement?
Yeah. See, that question is on Arbitration and Conciliation Act. Definitely, these clauses have now been rendered ineffective by n number of judgments right from 2017 Supreme Court till today. So 2019 Perkins came, 2024 5 Encore 2 came. All these judgments have categorically held these unilateral clauses, or these clauses conferring right upon one party to appoint arbitration, as null and void. So now, despite that, if a party is choosing to appoint an arbitrator on its own without the consent of the other party, then that can be challenged straight away under section 14 subclause 2 of the Arbitration and Conciliation Act, as well as during the course of proceedings. Suppose you have participated in the proceeding, then also you can raise a challenge under section 12 and 13 of the Arbitration and Conciliation Act. In fact, you can challenge under section 16 also, and ask the arbitrator to decide its jurisdiction. The principle of competence and competence provided under section 16 requires the arbitrator to decide its jurisdiction. So those remedies are there. Any further question?
Yes. One more doubt, sir. If the both parties place of incident is different, and both parties head offices in the different state, so how, and the seat will be decided by one party by himself, so how,
No. Please.
so how can the notice will be sent on the by the place of incident, or at the place where the head office of the first party and second party?
See, this situation will only arise in case the arbitration clause that has been executed between the parties is silent on the seat and venue part. Usually, the clause itself contains and provides for seat and venue. It in fact also, in certain cases where these clauses are not there, they also contain a clause of exclusive jurisdiction clause. Even if that is not there, then there is a doctrine where we, based on the proximate location of the parties, we decide which court will have jurisdiction, so where the cause of action has taken place, where the parties are staying. So all these factors will be taken into consideration while deciding the dispute. As mentioned by you, suppose one party stays here, the other party stays otherwise. we will need to see where the agreement was executed. If that is also in dispute, we'll see where the subject matter of the dispute lies. If that is also not there, then you may add from your place, invoke the arbitration clause, send a notice invoking arbitration, and then you may file your case based on the cause of action that has taken place in your jurisdiction. So number of factors need to be taken care of.
Okay, thank you, sir. Thank you so much.
You are welcome.
So shall I read this question for you?
So yeah, please.
Sir Mehek Thakkar, she's asking that, sir, can you please give some examples as to the circumstances where the dispute is not fit for any of the resolution methods of ADR, but the reason for the same is not public policy?
See, first circumstance is a criminal dispute. So suppose any offense has taken place in respect of which an FIR has been lodged under the exclusive provisions of now BNSS and BNS. So those disputes, those are covered under these acts, are not cannot be taken recourse to any of the arbitration mechanism or any of the modes of arbitration. Then 2021 Supreme Court held that disputes, those are covered by special statutes or specific statutes. Those disputes are not arbitrable. In fact, the Honorable Court held that disputes that are covered under the exclusive jurisdiction of DRT are not arbitrable. DRT under Recovery of Debts and Bankruptcy Act 1993. So those disputes are not arbitrable. The disputes which are covered by Rent Control Act, they have been held to be non-arbitrable. IPR disputes, there is a discussion going on. There is still a dispute whether these disputes can be resolved by way of an arbitration or not, where there is an issue with respect to intellectual property and copyright violation or patent violation. So all these disputes are there, which cannot be resolved by way of an arbitration. In fact, matrimonial matters have been held to be not able to be resolved by way of an arbitration. Contrarily, mediation has been the better recourse for resolution of matrimonial disputes or family disputes. So these are certain circumstances where arbitration or ADR mechanism cannot be taken recourse to. However, now since we are evolving, see, we need to understand that we are evolving. We have taken an approach where now under even BNSS, we have promoted community mediation in a way, community service say. So this is a shift from the traditional approach that any offense covered under IPC or BNSS say will be adjudicated only by traditional courts. That's not the case anymore. We are evolving, we are daily working to find out those petty nature of offenses which can be resolved by way of ADR. So one of the examples, in fact, is 138 offenses, Section 138 NI Act. Compounding is now being promoted by all the courts, that these disputes can be resolved by way of mediation. So we are evolving, especially criminal matters, complex disputes matter, frauds are there. These have been kept out of the purview of ADR. Any further question?
So I guess Mr. Abhijit Kumar Padhi is asking why the civil matters are more resolved. Okay, he's asking that why civil matters are only resolvable by ADR mechanisms and not criminal matters.
See, that's the single reason is a civil dispute is primarily between two or more parties, rather say, I would say individual parties. Criminal offense, on the contrary, is against society. So a dispute which is against society, an offense which has been committed against society, cannot be decided by way of private mode of resolution. mediation, arbitration, these are private modes of resolution of disputes, where private disputes are resolved. Criminal offenses are not private in nature, though they may have been what should I say, though may have taken place against one person. Suppose murder or any sexual offenses may have, the victim may be one, but it is against the entire society. The law recognizes that. So a dispute that is in rem cannot be decided by way of a private forum. ADR mechanism is purely a contractual way of resolving dispute. Arbitrator is also a product of contract. Mediation can also be said as a product of contract. So an offense which has taken place against a society cannot be decided contractually by the parties themselves. So that is precisely the nature why civil disputes are resolved by way of ADR and criminal offenses are not.
I guess so. There is another question. Mr. Ans Sharma says, "Good evening, sir. In matrimonial disputes, courts tender cases for mediation not only at family court level, but also at high court levels. And in almost each and every case, failure report is filed, which is unnecessarily increasing the time in deciding the dispute. So is there any way to bypass this obligation?"
In matrimonial send to the court, mediation only at not. See, the only way to bypass this process is not agreeing with the court whenever the court. You see, it is not that the courts force you to go for mediation. The court always asks you. You are required to sign a form that yes, you are willing to explore the possibility of settlement by way of mediation. So first way of bypassing or say not taking recourse to mediation is saying no to the court that you are not interested in pursuing the mediation. The second way would be, the second step would be before the mediator itself. You may appear before the mediator and say that you are not interested in getting your dispute resolved by way of mediation. The mediator will immediately return back the file to respective court. However, it is always advisable to explore the possibility of mediation because that is actually saving time and cost. We have been experiencing this as counsels, as mediators also, that it is in a way very effective process. Obviously, where a party has made his mind that he's not going to resolve the dispute by mediation, that is an altogether different situation. But in most of the cases, mediation is actually a practical solution and an efficient solution. Any further question?
I think we have come to the end of. Is there any question, guys? Okay. We have come to the end of the session. Thank you so much, sir, for
Thank
doing
you.
this. I mean, the session lasted for 1 hour, 20 minutes. Thank you so much, sir, like giving time from your busy schedule for this session, and that too in a Saturday evening. Thank you so much. Thank you so much for doing this.
Thank you. Thank you.
Thank you so much, guys. People can leave. Thank you, sir.
Thank you.